deal with the transitional provisions in the Companies Act and the action plan. I suppose this should be the most important topic because this is where we need to understand how we are going to move from the 56 Act to the 2013 Act. There are several issues and several questions which come to our mind. What happens to amounts accepted by the company as deposits which were earlier permissible but which now are not permissible? Such deposits, what is the action plan? Share application money which was accepted in the past, there was no limit within which the shares were to be allotted. Now there is a time limit within which the amount received as share application money is to be regarded as a deposit and you need to comply with the deposit regulations. What happens to such application monies which have been received in Turbo, etc. There are several such issues, and to guide us through all this, we have a very able personality in Mr. Mahavir Lunawat, who is the gold medalist in Company Secretary Final Examination. He is a law graduate as well. He has done his CFA, so you have a multifaceted personality in Mr. Lunawat. Apart from that, he has done postgraduate diploma in security laws, etc. On the experience part, the one is that he is a group managing director of Pentomath Advisory Services Group. He has exposure working with leading organizations such as Reliance Industries Limited, ITC, PricewaterhouseCoopers, etc. He has exposure of more than a decade in handling mergers, demergers, mega corporate restructurings, etc. He was elected as a member of the Western Regional Council of ICSI. He has been part of a special group company formed by ICSI, etc. And the list goes on and on. Now, I'm sure you are eagerly waiting to hear Mr. Mahavir Lunawat. Now, before I request Mr. Lunawat to deliver his presentation, I request Mr. Vipul Choksi to present a memento to him as a mark of our love and and now request Mr. Mahavir Lunawat. The presentation will be emailed to all of you. Right now the presentation will be available here and your copy will be emailed to all of you in due course.
Indeed, pleased to be part of this August gathering. I mean, it took a little longer for me to kind of be with esteemed fraternity and members of chamber. So that I contributed to articles and columns, but somehow I was not able to have one-to-one, and I think today is the day where I have the privilege of having this interaction. Well, topic summarized to me is, it was told in the beginning that it's very important. I'm not sure of importance, but one thing is very sure, that it's very vague and general. When I was asked to speak on compliances under the Companies Act, how do we transition from 56 to 2013, I was like in a couple of hours time mapping all compliances of Companies Act and discussing as to how we will transition from provision to provision, from section to section, from clause to clause, from rule to rule. I think it is a Herculean task, but nevertheless, I have some thoughts, and the idea is not to go through each and every compliance, but rather to discuss about the approach, the strategy, and of course, touch upon some of the key aspects, couple of them which were highlighted in the opening remarks. The views are purely personal. I must disclaim I need not be the views of any of the organizations or groups that I represent. During the discussion, we may take names of some corporates, some cases, some precedents, some of which might not be decided by courts, and the idea is not to make any comment or cause any dispute or harm to any of those corporates or cases, but these are purely for academic illustration purpose. With this, I will not add much of formal letter and straight away go to the topic for this afternoon. Well, when we look at transition, I have tried to kind of study and research this Companies Act. There are a lot of changes in terms of opening up some of the long-awaited areas, like for example cross-border mergers, or for that matter call put options, for which probably all of us in different capacities, whether as professionals or industrialists or businessmen, we had to fight for decades that why don't Companies Act, why doesn't Companies Act permit call put options, and in the guise of free transferability of shares of public company. There was always a debate that whether call put option can be enforced, and similar provision or similar restriction was there from SEBI when it comes to listing of those companies with stock exchanges were concerned, and similar problem was there with the RBI whenever there was a kind of transaction cross border. So fortunately, a lot of such issues have been addressed, and a lot of progressive provisions have been incorporated or brought in the statement book. But at the same time, we also witness some of the factors like you can't make investment to more than 2 layers of investment companies. So at times we are in a flux that what is this law all about, what it tries to achieve. When it is supposed to be a modern progressive law, how come suddenly there is a restriction on making of investment to more than 2 layers of investment companies? And that triggered me personally to go into detail as to what influenced this Companies Act. And from there, what emanated that why shouldn't I speak briefly on what influenced Companies Act and how the Companies Act influences us. And probably if we have some kind of thoughts on that, it will probably give some more clarity in terms of the intention of the legislature and the way forward of the intended compliances in letter and spirit. Well, if you go through the journey of this Companies Act, we will not spend much of time. This is more of theoretical, but nevertheless, a couple of points I would like to submit before all of you is that in India, as we all know, any parliamentary legislation of importance as what Companies Act bears is based on some kind of process which necessarily involves discussion at some kind of committee level. I was asked a question sometime back in one of such kind of forum that what is the document where we really can have some kind of justification or explanation on Companies Act, because fortunately or unfortunately today's legislation doesn't carry too much of detailed statement of objects and reason, unlike how we used to have in earlier years where we could have really the justification of the entire process. Right now, the trend is that probably we have one-liner or two-liner as statement of objects and reason, and we really don't find any real intention or justification of why that particular change is brought about. And that's where I think if we have to kind of have that one piece of document, that is JJ Irani Committee. As we all know, before this Companies Act was kind of formulated as a bill and formally presented to the Parliament, it had gone through a series of discussion papers involving concept paper from Ministry of Corporate Affairs, and then finally JJ Irani Committee looked into, and then the committee submitted its report. If you go through JJ Irani Committee, we'll find probably each and every concept of what we have in the new Companies Act touched upon either in brief or in detail. And I would say almost all the provisions or almost all the key changes in terms of concepts and policies, we will find a reference and the background there too in JJ Irani Committee. Now before that, we also did one more study in terms of what really influenced the committee to touch upon that. So let's say we have a provision in the Companies Act on, let's say, private placement or preferential allotment, as we call it, that there has to be an offer letter to be prepared even for private companies. Money has to come in the separate escrow account. So now private placement is also a sort of mini public issue for that matter. So what really triggered the legislator to make those provisions relating to private placement more stringent? And what led the committee recommend that yes, government do this or do that, or you don't do this or you don't do that, and we kind of call it as influencers. I don't claim that list is exhaustive, but I'm sure, or rather I sure that this is a demonstrative list. Well, we had two famous or rather infamous scams in capital markets. Ashok Mehta scam. Web of companies was used, of course, all of us are aware, prices were moved in a particular direction, and the same entity or same beneficiary owner was increasing or decreasing the prices. So how that was possible? Because I, as an individual entity, cannot do that. So what I have done probably, I have created a web of companies. So I created A, B, C, P, Q, R, X, Y, Z, A holding in P, P, Z, Z in C, C in D. Nobody knows that where the ultimate holding lies, and from somewhere the funds were kind of infused, and it has finally gone somewhere down the line to Z, and Z has lent to P, and then finally Q has sold and A has bought. And in the process, prices have gone up or down. And that's where this entire saga has happened. And the then Joint Parliamentary Committee unearthed or discovered, if I can say so, one fundamental device which was deployed in the entire exercise, and that was layers of companies or web of companies. And that's where from there it got emanated, and the committee suggested that there should be a restriction on investment through more than particularly defined layers of investment companies. And from there this concept was debated in government committees and expert committees from time to time. And finally, Yashwant Sinha led the Joint Stock Parliamentary Committee suggested that nothing doing the companies that will have or should have a restriction. Although Irani Committee recommended against that, you government, you cannot have a kind of total prohibition that there cannot be investment through more than 2 layers of investment subsidiaries. You have checks and balances, you bring out standard disclosures, but you can't simply say that investment is not possible through more than 2 layers of companies. But I think government had its own reason, and that's the background that we have the provision in the book, statute book, that no company shall make investment through more than 2 layers of. So that gives a lot of clarity that yes, there are 100 progressive provisions, but suddenly you come across a restrictive provision. So what could be the logic? So if we kind of connect this to the background, it gives a lot of clarity that yes, this is the background, and probably this gives a kind of clear vision in terms of what is the intended compliance of that particular legislation. Similar such, not similar to that magnitude, but another scam which was there in terms of having multiple folios. Fundamental law of India is that one person, one application in an IPO. But what probably one has done to get more allotment in an IPO is fictitious multiple accounts. So I have created various demat accounts in the name of, let's say, Mahavir Lunawat, L Mahavir, then combined with, let's say, XYZ, different combination, different permutations, and one person has created hundreds of demat accounts. We know which IPO I am talking about, but at that time, unfortunately, there was no provision in the Companies Act to deal with such cases, and SEBI and merchant bankers had to deal with on case-to-case basis. Finally, learning out of those incidents, there is a clear provision in the Companies Act that whichever combination is used by any person, there cannot be multiple applications. Not only those applications will be void, there will be, if any gains, that will be disbursed back, and of course there will be penal provisions and the fraudulent provisions for those. So that is again another set of provisions which are influenced by those cases. Well, lot of strengthening in terms of audits, internal control, financial control, board affirmation to have adequate financial reporting and control systems, by and large influenced by accounting debacles like what we had, and globally also what we saw in US, whether it is Sarbanes-Oxley Act or similar such legislation, and from there it got emanated that how our corporate act could be or should be more robust. Well, that way, if one has to compare on a very objective note, some of the provisions what Sarbanes-Oxley suggested, even the 1956 Act used to have. So, in that sense, our corporate laws are much more robust and much more strict or stringent, even compared to some of the Western world's laws. But nevertheless, we have picked up rest of some of the newly suggested norms in terms of auditor rotation, audit services prohibition. Well, there are views for and against, but I think we have kind of traveled beyond the views, and finally we are now we have a final piece of legislation. Well, again, Sahara is more of a demonstrative name. We have a lot of such schemes, maybe in the name of Ponzi scheme. We have had this case in West Bengal also, and that has directly influenced what we have, Section 42 and Section 62. All the provisions of that private placement, applicability of private placement to private companies, having a separate escrow account, no cash dealings, no share application money beyond, let's say, 2 months. All the provisions are by and large influenced or triggered by some such cases. Well, this is not a decided case, but to make it more general, let's say a company comes out with an IPO of 200 crore with a stated object of investment in setting up a unit or plant or manufacturing facility. 2 years down the line, company doesn't make use of the issue proceeds. Only 5% of the funds are used in the business purpose, and 95% are used as, let's say, investment or for temporary parking of funds. After 2 years, management comes out with an ordinary resolution to change the objects for using the issue proceeds from setting up of unit into investment of shares. Quite possible, ordinary resolution was passed and the issue proceeds were changed. And we all know how in the given setup of Indian kind of family owned and driven companies, if I can say so, how easy or how difficult it is to pass the ordinary resolution of more than a special resolution. Now think of those common investors who had put in money based on the prospectus and disclosure and the intended object of utilization of money for capex purpose, but suddenly ordinary resolution is passed post IPO and the purpose is changed. Would the recourse? No recourse under the Companies Act 56. And again, learning from those, now we have a full-fledged code, I would say, to deal with such cases. Not only you need special resolution, not only you need wide publicity, not only you need postal ballot, but it goes to the extent of saying that each and every dissenting shareholder has to be given an exit offer by the promoters or by the management at a valuation to be arrived at independent value. So to that extent, the Companies Act 2013 travels to protect the interest of stakeholders. You have taken the money from investors on a particular project with a particular object. Now if you want to change, no doubt you have to take the majority approval through the process. But those who are not in favor, you have to make an exit offer provided to them. So that's the kind of strengthening has been done, and as we understand, SEBI is working on such modalities of exit offer. So at least 5 to 6 places we find in the Companies Act this platform of exit offer. So wherever any important change happens, shareholders are not in agreement, they are definitely going to have this exit offer at a valuation to be arrived at by independent valuer. Again, nothing to comment on a particular restructuring, but certainly we read in newspapers that voting take place for corporate restructuring, and all the institutional shareholders, or rather, if not all, most of them who have voted against, their ballots are invalid. It's very hard to believe that institutional investors who have a dedicated investment desk, who has dedicated desk for proxy management, who deals in day out and day, in giving the proxies and filling up the ballot papers, it's very hard to believe that those ballots will be invalid on scrutiny, technical grounds. But that was, it is, because we are not privy to what happened inside the scrutiny room. Finally, the resolution was passed, although with a very thin majority. So to take care of all these cases, now the approval mechanism is very much strengthened. That you have physical meeting, in addition to that, the postal ballot, you have e-voting. So no matter where the shareholders are, they can cast their votes, whether at physical meeting or through postal ballot or through e-voting again. I invest in assets. Down the line, I revalue. I build my reserves or strengthen my reserves out of revaluation reserve. My business carries on. One fine morning, I give bonus out of my revaluation reserve, and I can take out money through reduction, through buyback, because that's my capital. Quite possible it was, and matter ended up with finally at the Supreme Court in the PLS case, and Supreme Court said that I cannot probably take into account the accounting norms and accounting prudence, because there is no provision in the Companies Act, unlike in the then CBDIP guidelines, that bonus cannot be given out of revaluation reserve. And finally, Supreme Court had to allow, and that kind of became a precedence in terms of capitalization of revaluation of fictitious reserves. Learning from that, 2013 has a specific provision like how we have had in the DIP and continuing with ICDR, we have a provision in Companies Act that there cannot be bonus out of unearned reserves. So the point is, there may be various such background, various such cases, but if we link the changes with kind of a particular happening or cases, we have a lot of clarity as to in what direction these compliances or provisions are intended to be met with. When we take any major or minor change, we will find some kind of recommendation by J.J. Rani. I will not develop on much, because now I think we are much beyond the committee level and the recommendation level. We now have that, but only limited point I probably whenever we transition or we have this shift from 56 to 2013 Act, in all probability we may find some kind of input or solution in this committee report, and wherever we have doubt, please do check with that particular committee recommendation. We will circulate the presentation to some of this stuff which is more of, let's say, theoretical oriented. Maybe we can go through it easier. Now, before I move forward, I would like to put a small question just to kind of steer the discussion. That what is that one change in the Companies Act? That one change which according to you is the most important change in the entire Companies Act, read with the rules and circulars and all. Any views, please? CSR is, let's say, most important. Any more important change than this? Private company and public companies are on par.
Safety of all public shareholders, be it private company or
shareholders' interest, some of which probably we had touched upon in terms of giving of exit offer, etc.
Section 185.
185. You cannot give loan to your own subsidiary, and that is something which probably they have gone overboard, and I think some kind of review is inevitable. But as of now, holding company cannot give loan to its subsidiary. Then who will give loan? If holding company only doesn't fund its subsidiary, but that's how it is. But what is the most important change? I have studied slightly differently. When I first talked to my team, they started laughing at me, and probably you may have the same response, but I will still dare to share with you. The way I look at Companies Act, I look at from a behavioral aspect. And when I kind of discussed with my team, they said that I hope we are discussing the Companies Act and this is not behavioral management session, be it as may. The way I look at that the Companies Act, it kind of has a cultural shift. It completely changes the behavioral pattern of how a corporate is governed or run. And I think that's where if we can hit and understand in whichever capacity we work with, we will be able to achieve effective compliance. Because whenever I talk to fellow professional friends, etc., we always get into what are the compliances, which form was to be filed, which is not to be filed, which is the frequency has changed. But I think the way I look at, we need to have a totally different perspective. I will elaborate on this point and will park this point for the time being. So we saw how and what influenced Companies Act. We discussed some of the demonstrative cases. Now, taking it further, so there are particular background, there are particular cases which influenced Companies Act, and in turn Companies Act have influenced what we now have various provisions. So touching upon that aspect, this is how the classification or the coverage goes in terms of scope of applicability of Companies Act, and they have very minutely covered each and every aspect of corporate functioning, whether in terms of size, in terms of number of members, control, liability, or manner of access to capital. And if we go through Irani committee, this is precisely what Irani committee has suggested, that we should have all kind of companies covered and respective provision for that. Of course, in the final act, as rightly mentioned, that some of the lot of the provisions of public companies have been made applicable to private companies, but nonetheless there are classification and there are a lot of provisions specific to each type of companies as described in respective boxes. Well, there are a lot of changes, but some of the changes which probably have far-reaching implications.